Hello, I'm Danielle Mciver, Chief Product Officer at the Family Office. We're pleased to host a further webinar in our Offshore series looking at wealth structuring. Today's topic is going to be planning for family disputes. And I have joining me Jeremy Kosky, who is a senior partner at Clifford Chance law firm based in London with regular travel to the GCC region. He focuses on advising high net worth families, individuals and trustees on disputes and litigations. So thank you for joining us, Jeremy.
Thank you very much for inviting me.
So shall we jump in? I'm really keen to hear from you on this topic. I think you've come across many different scenarios over your kind of 20-year career. So it would be great to kind of kick off with what kind of family disputes have you seen? What typically arises?
Typically, the disputes are around control, money, and power in a family. Often there's one side of the family that works in the business, generates value, the other side perhaps less involved in the business. And the questions will be, do one side deserve more value than the other? How do you recognize contribution? Do you discriminate against individuals who don't work in the family and have alternative careers, no matter how successful they are? Sometimes it splits between different branches. So you'll have a founder, you'll have 2 or 3 children, and those different branches will squabble and dispute and often end up in court over how to divide up the family wealth. Sometimes it's within a branch. So perhaps a founder dies prematurely, leaving 2 or 3 children in their 20s and 30s. There's a whole range of different disputes, and families can splinter in all sorts of different ways.
Okay, and how is there normally a trigger event that kind of leads to these disputes? What's normally the catalyst for a dispute like this unfolding?
There are various different catalysts. Death, sadly, is often one of them. We had one case where a Greek billionaire, shipping billionaire, passed away having given all of his wealth to one granddaughter, so one child of one of his 4 children. The immediate reaction of the 4 children was, did he not love me then? They just didn't understand why he'd made no provision for them. The granddaughter came to us and said, I don't want a big dispute in the public domain. I'd like to resolve this. Help me sort it out, which was a brilliant attitude for her to have. And Greek inheritance law rights, similar to Sharia law rights, gave her mother and her aunties a fractional share in the estate, and we helped her sort it out. We helped her explain how she would have to deal with her grandfather's passing, respecting their inheritance rights.
It can be very, very sensitive for that person that is named, as well as those that may dispute it that are kind of not named, right? So it's good to hear. So you act on both sides of the fence.
Absolutely, on both sides. I think the grandfather in that case had earmarked her because she was definitely very business savvy. She knew how to run that shipping business, and she was a very clever person. She was also commercially very sound. But I also think that he thought that she could bring peace to the family after his lifetime in a way that he thought he couldn't do himself, which was a remarkable act of self-awareness on his part to find the next generation that would bring the family together, whereas he felt that he wouldn't be able to do it himself in his own lifetime. You don't often see that, I have to say.
Yeah, no, absolutely. That's an interesting one. What else, Jeremy? What have you, are there any specific cases perhaps that have touched the GCC region that you could share with us?
Sure. We acted for a trustee in the Channel Islands a little while ago, defending claims brought by a Saudi family. The Saudi family were 9 siblings. One of the siblings had been given authority, power of attorney, to invest on behalf of the other 8. And he put quite a lot of money into a trust in Jersey. Unfortunately, the investment management went awry, and significant monies were lost. And when the other members of the family found out, they sued their brother and the trustee. That was a very difficult case because in some ways the brother was embarrassed that he'd lost this money. He wasn't deliberately taking it for himself. He was making what he thought were sound business investments. But when they went wrong, he found it almost impossible for himself to actually reveal to the rest of the family how things had gone badly wrong. And the trustees ended up having to try and play a role of educating the rest of the family about the decisions that had been made, why things had gone wrong, and then bringing the matter to a resolution. But that was very hard fought litigation for quite a while, because the rest of the family were really upset, partly that the money had been lost, but then partly in the way in which their brother hadn't been transparent with what had happened in a timely fashion. And he had really forced them to go to court to get disclosure of information and that financial transparency.
Right. And that's actually an interesting scenario that you bring up there, because I think that can happen quite a lot in families where there's several, siblings, and potentially the oldest sibling has the authority to kind of do the execution on behalf of the family. So if we have any clients in that scenario listening, is there anything they can kind of do in conducting their duties like that to avoid these kind of family disputes unfolding? Is there any advice you could give for that?
Sure. I think the most important thing that didn't happen in that case is the trustee didn't have an annual family meeting. I think it would have been really helpful for the trustee to have said, once a year, we want to see all of the principal beneficiaries, all 9 siblings. We're going to go through the investments over the past year, any distributions that have been made, what the future intentions are, and just get everybody on a level playing field in terms of understanding what's going on in the trust. I think that failure to invite the 9 to a meeting was really quite important. And that's what I tell clients: always try and have regular family meetings. And then you need to think about where to have the meeting. When the matter I'm referring to blew up, the first letter that the trustee wrote to the other side of the family was, come to Jersey and we'll try and find some material and information that we can provide you. That was a pretty unwelcoming letter. And when it was read out to the court in the Channel Islands, the court was very unimpressed. The court was basically saying, look, if you've got a family based in Saudi, perhaps you might suggest going to Saudi to meet them locally, or meeting in Paris or London, somewhere convenient. But to say as a trustee, come to Jersey and we might be able to get you some information, was really not the way. So I would say to trustees and other fiduciaries, be on the front foot, provide information, be forthcoming with the information about the investments, make the family feel that they are wanted and that their requests for information, their understanding about the investment is first point on your agenda.
I think that's an important, I agree. And I think it's actually an important point for clients thinking about selecting a trustee. What is the appetite of that trustee to actually travel to the region to have these annual family meetings? Is it really practical for, are you going to get the engagement if it's done virtually? Is it really practical that all of the family members are going to come to the Channel Islands or the Caribbean for this annual family meeting? Probably not. So I think that's a really important aspect, actually, when someone is choosing a trustee, to make sure that the trustee is going to be willing to kind of come to them to work through some of these things in the planning. So, I think that's a really helpful starting point in terms of planning to avoid some of these disputes. But what else could you suggest, Jeremy, in terms of how families might go about planning to avoid these disputes?
In certain parts of the world, the elder statesman or stateswoman's lifetime is a bit of a taboo subject. I hosted a round table in Hong Kong a few years ago now, and we asked the clients around the table, what keeps you up at night? And there was a deathly silence, and I thought, oh gosh, we've asked the wrong question. And then after 5 seconds, although it felt like 5 minutes, someone put up their hand quite sheepishly and said, how do I ask my father what's to happen after his lifetime? I just can't engage in that subject, talking about what's to happen. And then everybody else put up their hand saying, I've got the same problem in my family with my mother, or whatever it was. That was the big issue, sort of asking the founder, perhaps the original wealth generator, what would you like to happen after you're no longer with us? Do you want one granddaughter to run the shipping business? Do you want all of the family to engage? Do you want all of the family to work in the business and then to benefit from it? Or is it okay if some people have non-business, more academic careers? So really identifying with the original patriarch or matriarch of the family, what they would like, and engaging in the discussion. Some families start to write that down, and they sort of create charters and protocols and other family governance structures sometimes legally binding, sometimes not. There are pros and cons. But the act of sitting around a table and asking, how are we going to be as a family over the course of the many generations to follow, the many decades to come, is a really difficult topic initially, but it is quite cathartic. Actually, people will express different views about how they see life progressing, how the family should hold itself out. And quite beneficial, I think, to sort of engage in the writing up of a family protocol, a charter, governance. And you'll identify things like, should we meet as a family once a year with or without the trustees, with or without our intermediaries and other advisors, to just discuss the issues in the family. Families are dynamic. People get married, others join the family as a result. People pass away, people have children. There's a sort of a very fluid, dynamic process. But as I say, I think the key thing is sort of engaging in that taboo subject. Certainly in some parts of the world, even asking your elder what's going to happen after your lifetime is really difficult. There's
Yeah,
another
so
sort of related, sorry, Danielle.
no, I was just going to say, I think it's really important that there is someone in the family that kind of steps up to, I guess, raise the topic to start the conversation, right? And I think it's how they position that is often really sensitive to kind of get it started. So I think you're absolutely right. That can kind of be the hurdle sometimes that people get stuck at. And then when the conversation is opened in the right way, actually, you can hear from the other family members exactly how they want the future generations to be. So I totally agree with your point.
Yeah. There's some families find it very difficult to engage directly, sort of elder to younger generation. And the role of someone who's not a member of the family but trusted by everyone in the family is really important. We had an example relatively recently where the head of the family office has acted as a brilliant go-between between the settlor and the younger generation. The settlor had very fixed views about how much he wanted to endow into a charitable foundation that he'd set up. The younger generation weren't so keen on quite that plan. They bought into the idea of a charitable endowment, but they didn't like the amount and the nature of the assets going to the charity. But the head of the family office actually stepped in and had parallel conversations both with the settlor and the next generation, and really enabled everybody to come together. And in the end, everyone was very happy with the outcome. But that individual in the middle who didn't have a personal financial interest in the foundation or the trust actually was able to just take a step back and enable people to speak to one another. So sometimes just not having the individuals directly facing off against one another is quite important. And if you can use a mediator or a family office or some other trusted advisor, can be really, really helpful, really helpful.
Yeah, right. I think that's a helpful piece of advice, I think, for our clients listening. So thank you for that. I think the independent person can be really, really useful. Okay, so we've talked a little bit about kind of planning. I am curious as to your thoughts as to how an offshore structure could help with some of this planning and I guess mitigations against these disputes. So what are your thoughts there?
Certainly in terms of offshore structures, I love trusts in the Channel Islands and Bermuda in particular. There are other jurisdictions as well, but those are sort of my favorite too. In the Channel Islands, you've got very strong judiciary, very strong practitioners who end up becoming judges, who really understand trust law, and it goes back many centuries. And you've got predictability. Clients like the Channel Islands because of the predictability of the outcome of the cases when they go to court, and the ability for the local bar, which also is very strong, to advise on the way in which certain matters would be dealt with by the courts. Bermuda perhaps has a slightly different bar and a slightly different judiciary, but it does have a very valuable piece of trust law called Section 47, which enables changes to be made where they're expedient. And I've used that to make quite significant changes to trusts in the past. So those are my two favorites. The reason I like trusts is because you end up putting ownership of the asset, which might be a very valuable family business or liquid investments. You put that into the hands of fiduciaries. So non-beneficiaries, often professionals who might have a range of other trusts that they are familiar with, who bring that professional experience. And they're there to protect the asset ultimately. So we had one huge case in Bermuda 20 odd years ago where the settlor tried to revoke a trust he'd set up 15 years earlier. And he made allegations of undue influence against his son and the trustees. And the case raged for 5 years, but the company itself remained intact. So the battle was at sort of a higher level, the ownership level, settlor and trustees and beneficiaries and protectors. But the actual business itself remained intact. And although it wasn't great for the business that the CEO, the son, was being attacked in the court, actually there was an ability to dislocate what was going on in Bermuda from the rest of the business and the management of the business. And to my mind, that's a sort of paradigm example of how trusts protect the underlying business, even if there's a battle raging over ownership and control, ultimate control of a business. They can, in fact, protect the asset in the meantime until that dispute is resolved. So I like trusts for the protection that they give. Frankly, also, trustees, professional trustees will be insured. There'll be deep pockets if things do go wrong, and sometimes things do go wrong. Trustees can be expected to make amends financially to the trust. So putting an asset into the hands of a professional trustee is a very powerful way of protecting the family's interests for the benefit of the family as a whole.
Yeah, so I guess to summarize there, so we're saying dislocation, it removes it from kind of personal litigation on any individuals and allows the business to kind of continue. And I guess professionalism of the trustees. And I guess with that, you have the governance. So these trustees are all, if you use a reputable one, very highly regulated, have a lot of rules they have to comply with, very high governance standards. So I think families can kind of take that comfort. And also by, I think you said by structuring in, say, the Channel Islands or the Caribbean, any challenge against assets held by that trust would have to be brought in the courts of the Channel Islands or Caribbean, which have, very strong case laws. So there's a lot of predictability as to how a case would be ruled. It's, there's many, many years of cases where similar disputes have been brought. So does that kind of summarize generally the benefits for kind of disputes in using a trust?
Yes, it does very much so.
Okay.
There's a slight variation. Some clients prefer private trust companies, so that's where the company itself isn't only managed by third-party fiduciaries, but members of the family or potentially close advisors of the family will sit on the board of the private trust company. That's a variation that we see some families preferring, where they're concerned about who exactly will be making the decisions. Some families are very happy with the third-party trust company, but they like a protector, someone who's going to act as a watchdog over the trustee's behavior. And the protector typically will have family members or close advisors. So there are different ways of getting families comfortable with offshore structures. There isn't a single approach that you have to do it this way. There are ways in which families and their different dynamics can get more comfortable with the trust structure.
Right.
But yes, very malleable as a product, very reliable and pretty predictable. And in certain jurisdictions, the courts are strong, will give you good decisions in quite a timely fashion as well.
Okay. And if we talk about the risks if someone didn't take a trust, so they leave all of these assets to kind of the executors, so let's say they're a Saudi family and they may have assets globally. If somebody passed away and one of the heirs wanted to bring a challenge, where would that challenge be raised? Would it be raised in Saudi Arabia? Would it be raised in the jurisdictions of all the assets? How would that process differ? And kind of what benefits or disadvantages would you see if it was unstructured?
If assets were held in the late settlor's own hands, then typically his heirs would have inheritance rights in Saudi. They would probably wish to enforce them in the Saudi courts initially, because the Saudi courts would certainly uphold their inheritance rights. Then taking that Saudi judgment and trying to enforce it depends on which jurisdictions the assets are. Obviously, if the assets are held in a trust, typically, certainly in the Channel Islands and Bermuda, there's legislation which says you can't take your inheritance rights that you may have in a foreign jurisdiction and bring them to attack a trust. to try and amend it. So the trust industry, if you like, is designed to withstand inheritance rights being used. And the reason why clients like trusts for that reason is they don't like the idea that on their death, a business will be broken up and suddenly you have 10 heirs all having 10% of a company, because they think that fractional ownership is very divisive. So they like the idea of keeping assets under centralized control where everyone can benefit from them, but you then don't have a shareholder dispute. So the opposite, where you don't have a trust and assets just pass through the estate, you could end up with inheritance proceedings, in your case, Saudi and elsewhere in the world, trying to enforce against the assets wherever they are, which would certainly be an expensive exercise and a slow one. And again, on the passage or passing of the founder with a trust structure, then there is no battle over the assets. They're held centrally for the beneficiaries. So it's a very, very different dynamic, a very different profile. The other thing to bear in mind is if assets are held in individual names, it's not just death, which is the trigger. Incapacity is increasingly, I've got a number of cases ongoing at the moment where the capacity of the settlor is being challenged. And if in their latter years they are losing capacity, then there can be all sorts of disputes over who then is the decision maker, even before death. There are mitigants in this country. In the UK, you can have a lasting power of attorney to provide for a different person to have the decision-making authority during the settlor's incapacity in their latter years. Those aren't always possible in other jurisdictions, but there are certainly potential for disputes where assets are held in the name of the settlor right until the end of their lifetime, much more so than if they are put into trust whilst they have capacity.
Yeah, okay, that makes sense. And I guess raising again the power of attorney point there, it goes back to what we spoke about at the start. If you have one person in the family with a power of attorney and then you have who's suddenly in charge, and what happens then if you get all of these different family members that don't agree with the decisions under that power of attorney? So I think it circles back to the original point that we made. So thank you so much, Jeremy, for sharing your experiences and knowledge on this. I think this has been a really, really helpful introduction as to the kind of disputes that can arise and how they occur. And I think to summarize, you kind of said, if people want to start the process in planning for this to avoid the disputes and to mitigate against these kind of problems, the very first step is just having that discussion in the family about what kind of the long-term intentions are generation to generation. And, you know, there's varying steps in between. And at the most kind of advanced end of the planning would be to have a trust structure or similar, that could be a foundation, it could be something else, in place to actually have more control and certainty over what would happen if there was a dispute, and I guess maximizing governance around the operations. So thank you. I hope this is helpful for any clients that are listening. Please do reach out if you have any concerns or want a discussion around planning for this. Jeremy, are there any final remarks you would like to make on the topic? It's obviously a very broad one. I'm sure we could talk for a long time on it.
Yeah, you've summarized it brilliantly. Thank you very much for inviting me. Thank you.
Perfect. Well, thank you so much. And we will close here. Thank you for watching.